Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising.
Welcome to AI Council Code. AI Council Code is here to keep you up to date on all the AI legal issues arising in the modern business frontier. I'm your host, Maggie Welsh, and today we're going to be talking about open source and AI. And it's clear that AI assisted code generators are becoming an integral part of software development for streamlining work and enhancing productivity. And according to Computer World, a Gartner research study predicted that by 2027, about 70% of professional developers will be using AI-powered coding tools, compared to what seems like less than 10% in late 2023. So today we're joined by Andrew Wilson, an attorney in Baker Botts' Washington, D.C. office, who has for many years studied the legal risks associated with software and open source licensing, and is here today to talk about some of the legal risks to be thinking about with open source and code generator software. So hi, Andrew. Thanks for being with us today.
Hey, Maggie, thanks for having me on.
So why don't you introduce yourselves to our listeners, tell them a little bit about your background and your work with open source licensing.
Yeah, I've worked with open source for basically my entire career. I started as a software developer. At that time, I made a lot of use of open source technologies, incorporating them into the source code that I was actually writing. But I didn't have really a holistic understanding of what the implications of some of those open source licenses meant. For example, downstream use of the products I was developing. After attending law school, I began practicing primarily in M&A and due diligence investigations. I would come across open source licensing issues. And at that time, I finally did realize the ramifications that can come from unscrupulous use of open source software. And so now that open source practice has really grown and become a pretty big part of my practice.
Great, Andrew. And so just to level set for everyone, what is open source? And as we talk on this podcast, how is open source related to AI?
Well, at a basic level, open source is a software licensing philosophy that prioritizes creating the best possible software above all else. And the best way to accomplish that goal under the open source philosophy is to remove all restrictions on downstream users' use and enjoyment of the software. So essentially getting the lawyers out of the way and removing all proprietary license restrictions so that the software is free for anyone to use, inspect, modify, improve, etc. Now, the goal is to minimize barriers to use and to maximize the user base, thereby creating theoretically this large community of essentially free labor, engineers, researchers, scientists, and even home tinkerers that are willing to collaborate and commit their time to fixing issues or adding new features or improving the software because they realize that the benefits of group collaboration outweigh the value that might otherwise be obtained by not sharing those improvements. Those same principles of transparency, collaboration, and freedom actually gave rise to modern AI systems. So early open source AI projects flourished under contributions from academic, research, and commercial contributors, and turning those projects into the most widely used AI systems. In fact, many of the largest AI tools started as open source, and many continue to be open in most regards. So there really is a rich history and relationship between the open source philosophy and the development of today's AI models. Now, I'll just caution that I'm using the term open source in a very broad sense here. There is a strict definition of open source as promulgated by the Open Source Initiative, and many of the so-called open licensing models that AI tools are released under, sometimes referred to as RAIL licenses or responsible AI licenses, they don't actually meet the open source definition. For example, publicly releasing code and weights for an AI model, but restricting their use to only non-commercial research uses would not be truly open source under that definition because there is that non-commercial restriction. Other common AI licenses have other types of restrictions, like they don't allow for use in law enforcement or in immigration systems. Again, these are not truly open source because the user is not truly free to use that software how he or she wants to.
Great, thank you, Andrew. That's really interesting. And you touched on the difference between proprietary AI models and open source AI models. So can you explain the distinctions between the two and maybe some of the benefits or disadvantages of the two systems?
In general, proprietary AI systems tend to benefit from access to more robust and larger data sets. or data that's been better refined or classified for a particular purpose. Proprietary AI systems also tend to work better right out of the box. They're more useful for the particular purpose that they're being marketed for. They tend to benefit from more rigorous sort of application-specific testing and may have some fine-tuning to have less offensive or more socially acceptable outputs. In contrast, open source AI models tend to face challenges due to more limited access to data, and that data is usually less refined than the proprietary counterparts. Open source models may be more raw, they may require more fine-tuning or further development in order to be suitable for a particular purpose. And there's concern about outputs from open source AI models and their testing, in particular about generating personally identifiable information or other inappropriate content. Still, with open source AI, you have this notion of improved accountability and trust that by having access to the code and pre-trained model weights, that you have increased visibility into how the system operates over, say, a proprietary or a closed model. Some have asked whether the benefits of open source architectures actually outweigh the potential harms. In fact, there's a sentiment that proprietary model providers are the only ones truly incentivized to actually police their outputs because there's some formal liability structure in place to hold them accountable. By contrast, a lack of indemnification and decentralized responsibility structures are sort of hallmarks of open source models, which make it difficult to force change in those models through accountability structures. So you see this formally recognized in the EU AI Act, where there's a recognition that open sourcing or releasing model code, data, and weights under an open source license might get you out of some regulations, but only gets you so far. For example, open source AI models that qualify as high risk and systemic risk general purpose AI systems still require performing significant compliance work to mitigate the risk of harm from those systems under those regulations. In other words, current regulations recognize that open source alone is not the answer to ensuring ethical AI systems.
That's really interesting, Andrew, in terms of the EU AI Act, how it is recognizing that open source alone is not the answer. And then also you mentioned that contrast between proprietary software and holding the owners of that proprietary software accountable versus open source and that theoretical model. It doesn't allow necessarily for accountability. So, what are some of the types of legal risks that you see for users that may want to use open source AI systems?
My advice for users of open source AI systems is to first understand that there's tremendous ambiguity in that term, open source. That phrase tends to get thrown around a lot, but it means different things to different people. Critically, just because a model purports to be open source doesn't mean you don't have to read the license or documentation, or that you can go ahead and incorporate that model into your business software without further legal review. Instead, any software, including AI tools, should be subject to legal review and approval before being put into use. Second, code is just one part of an AI system. AI systems also include data and pre-trained weights, which are applied to the model and derived from training on the data. So you should ensure that the open source license actually applies to the entire package, to the code, the data, and the trained weights and parameters before feeling satisfied that the entire system is in fact open source and permissive to use. So for example, consider an AI model that is advertised as being licensed under the Apache 2 open source license, which is a very permissive license. Some developers might see that and think that they've done their diligence and can go ahead and move forward and use the tool. But I've seen several instances where that open source license only applies to the code itself. It did not apply to pre-trained weights, which were actually licensed under a non-commercial use license. And the explanation regarding that non-commercial use license was not actually found until way down where there was a small disclaimer about who to contact for a commercial license. We see these issues all the time in diligence investigations. My second piece of advice would be to be careful about use of generative outputs. The issue here is that all AI models, whether open source or not, are trained on vast amounts of copyrighted data and could be used in ways that reproduce copies of that training data without permission from the original author. Courts are still sorting out what the infringement liability landscape will look like, and there are plenty of lawsuits teeing that question up. But just know that there's some non-trivial risk of an infringement claim for unregulated use of generated outputs from some of these systems.
Great, and that's a nice segue into my next question, which involves AI code generators. Because as you mentioned, and everyone I'm sure has seen in the news, there's a lot of active lawsuits related to these systems. So first, what are AI code generators and how do they work?
AI code generators are a type of generative AI tool where the output code is based on a user's prompt. There are two basic modes of operation. One is sort of conversational, like a chat window that can answer programming related questions, can propose specific suggested improvements to the code or organization of the code, or it can provide some sample code. And the second mode of operation is like an autocomplete function where large blocks of code are generated and inserted directly into a code file in response to a prompt, such as a code comment. These tools are sometimes referred to as pair programmers because they function very much like a second set of human engineering eyes in the pair programming development methodology.
So, how are these models trained, and does the training process present any legal issues that you see?
Yeah, all these tools are trained on real code written by human developers. That's important because it means that a large number of individuals or organizations actually own underlying copyright rights in the code that these models are being trained on. And those individuals have conditioned public use of that code on the user performing certain obligations or complying with certain obligations under the open source license. Now, this presents some potential issues for users because the code generators are alleged to produce copies or at least modified versions of the open source code that's being used in training. But they do so in a way that is difficult, if not impossible, to trace back to the original author. So end users have no idea when open source code is being reproduced in generated outputs, and they certainly have no idea about those pertinent open source license obligations. In fact, there's an active case involving claims that AI companies violated these open source licensing terms by creating systems that fail to satisfy those open source licensing obligations within their generated outputs. Now, the primary risk for users of these systems is liability for copyright infringement for incorporating the output of these tools into other software. For example, if an AI code generator produces a copy of a block of code that it was trained on, and a user incorporates that snippet into their own code, the user may face liability for direct copyright infringement from the original author. If the user then copies and distributes their code, they or potentially their downstream customers may face further liability as well. The code generated by these tools can also import other third-party code libraries that the end user may not be aware of, which may have additional risks in terms of licensing or security concerns. Now, with that being said, many AI companies are offering indemnities to shield users from third-party copyright infringement claims. It's unclear how actually effective those provisions will be in practice, particularly where you're mixing generated outputs along with custom-developed code, but nevertheless, those indemnification provisions should provide some comfort.
Thanks, Andrew. And I agree. I think the indemnification provisions that are being offered is something that we're watching closely too to see how that develops in practice. You mentioned earlier that it can be difficult for code generator user to determine if they have open source code or third-party code in the code that's being generated from the code generator. What suggestions do you have for an organization that might want to minimize risks from using a code generator?
Yeah, I think there's a few things you can do to minimize risk. First, I would enable that duplicate detection filter on the AI code generator if your AI code generator has one available. This ensures that generated outputs are not identical copies of training data and minimizes some risk, at least to the vendor. Vendors also recommend tagging code generated by AI tools, so adding a comment before and after every block of code that's generated by an AI code generator. However, it's unclear what practical benefits that approach provides. In other words, do you then have to do a second pass through all developed code to look for code generated by AI tools and then somehow search the internet for matching snippets or matching code blocks? So it's unclear what benefits that approach provides. Another suggestion that I think is more practical is to regularly use code scanning tools. These tools can be quite complex and have a lot of options and features, but in general, you want to find a tool that you can run at regular intervals. So in other words, outside of an audit context, and maybe a code scanning tool that you can run sort of with every build or intermittently throughout the build process. And you want to make sure that that code scanning tool has snippet scanning functionality, because again, what we're concerned about here is an AI code generator inserting snippets or blocks of code into code files. And that means looking for a tool that looks not just for third-party libraries, but also for those snippets. And just to be clear, simply running the scan tools is not enough. You actually have to diligently investigate the results and do something about them in order for them to be worthwhile. And the review of the scan tool reports does take some degree of legal knowledge into at least open source licensing. And that's something that we at BakerBots regularly do for clients.
Great. Thank you, Andrew, and thank you for sharing your insights on the topic. I know that it's a topic that a lot of organizations are facing right now and have a lot of questions on. So thank you very much for being with us today. And thank you to the listeners for listening to AI Council Code. We're so glad that you joined us today, and stay tuned for additional podcasts and more insights on AI legal issues from Baker Botts.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.